Yes. Okay, what's up, guys? I want to talk about a couple of topics today. I want to go through some of my outline with you guys and see if you guys can get a cool understanding of some of these really interesting torts concepts. So, excuse me if I'm a little tired. I've been kind of working on this outline from like 8 a.m. till today. Outlining is actually a really tough process because you're having to synthesize the information, see which cases apply to the concepts, and also put in some potential uh, uh, things that can help to combat some thoughts. So a lot of things I'm going to say doesn't make any sense at all, which absolutely shouldn't. This is like our first session, but it's a really cool idea to just kind of walk you guys through what I'm learning, discuss some of like the basic facts of the cases, and see, in what ways, you can kind of see what your first year class will teach you if you go to law school. So let's share my screen. So far, all I've done is, intentional torts. So there are more intentional torts than these three, but we've only done battery, assault, intentional infliction of emotional distress, otherwise known as IIED. Each of these, we're going to go through some of the elements, the prima facie elements that show whether or not you have IIED, assault or battery case. A civil tort that we have, of course, is negligence. And we're going to go into prima facie elements of that. Alongside with the elements, we're going to be talking about certain cases. You can, of course, use supplemental material from Quimby to help you see more about these cases, or if you can, use LexisNexis, or for free, I think Case Text kind of has a case there. You can review them for yourself. All right, so prima facie cause of action with case examples. So the first one is battery. And so the element of, so the thing here, so when you see a D, the D means defendant and a P means plaintiff. When you're in law school, you're not going to write plaintiff out a lot of the time. You're not going to write defendant out. Sometimes you're going to have to do it in shorthand. You're going to have to abbreviate it. So to prove a battery, you have to show the defendant made an act, right? That intended to cause contact with the plaintiff. Another note, the defendant is the person who the case is brought against. So for instance, in a criminal case, a lot of time the state, it's going to be like State versus Jones. So the state is bringing up a claim against Jones for committing a crime within the state. So that's when you have that. So anyways, so to prove a battery, you have to show the defendant made an act and that they intended to cause contact with the plaintiff, right? And really interesting, right? The defendant does not have to intend the contact with the plaintiff to be harmful or offensive. In fact, they might affirmatively believe that the contact was not harmful, right? And so a case that I'm using to defend that point would be Paul v. Holbrook. In this case, right, Paul was working at her job. Holbrook was very adamant in his attraction to her. In certain instances, he would touch her, and he would, and thinking he was being flirtatious. But as we know, since she was specifically saying this was not something that she wanted. She did not want to be touched, and he was still touched her, despite the fact that he did not think he was being harmful or offensive, because she did not consent to the touching. It was harmful. It could be seen as harmful or offensive. And the holding for Paul v. Holbrook was that a battery claim does not require evidence that the defendant intended to and actually caused harm, so long as there's evidence that the defendant intentionally touched the plaintiff in a manner that could be deemed offensive. So what does this mean, right? So you're going to receive holdings from the way the judges are going to be expressing the case within the case you're getting in class. A lot of time for me, I try to synthesize the holdings, and I think of them like a rule And so this is important because when you take the law school examination, you're going to have to use these rules to help you analyze a list of facts that we call issue spotting exam. Another thing about intent, right? Um, a lot of the time, you know, intent is found through evidence of the surrounding event. So substantial certainty counts in intent. So I put, for example, shooting in a crowded street, Fifth Avenue example, like Trump said, right? You might not intend to shoot anyone, but if you go outside into a crowded street and you pull a gun and you shoot it, you could be substantially certain, right? It is foreseeable that you would hit someone with the gun. Hit someone with the bullet, not with a gun. Excuse me. Transfer intent applies in battery. So let's say if you shoot someone other than the person that you intended. So let's say you try to shoot Dave, you miss Dave and hit Peter. So then transferred intent is that makes it seem like, or in transfer intent terms, it transfers the intent. So you actually intended to shoot Peter. So you can't argue the opposite saying, well, this is not a battery because I intended to shoot Dave and I missed and hit Peter. No, the intent transfers over to Peter. However, let's look at this one right here. This is a point of just a deviation. However, you're able to draw a distinction between the property tort committed and how the defendant ended up injuring a person. For example, you are trespassing on a property and you step on someone who's in the house and you injure them. Well, you can see that intent transference is not automatic. You can make an argument like you didn't know this would occur. So this is a different tort all in itself. So you're done there. And then right from the previous point, oh wait, hold up. 1 second, guys. 1 second. I think I missed something here. 1 second. Let me see something. I'm so sorry. So sorry. Okay, guys, I'm back. I am so sorry about that. I put an intentional contact can be battery. I immediately knew that that was wrong. So you have to intend the contact. You don't have to intend the contact with that specific individual, but you have to intend the contact. So unintentional contact cannot be battery. So for instance, if someone is having a seizure and then they fall over and they hit someone, right? That is not a battery because it's unintentional. Another point for contact. So contact does not need to be direct. It can be indirect. So for example, I put a bullet shot from a gun, making them ingest like a poison or an attack from a dog. One case that we can use as an example is Leitman versus WLW J Communication. So in this case, an anti-smoking advocate went to a radio station, and the gentleman smokes his cigarette and puffs it in the guy's face. The gentleman sues for a battery, and the argument from the defense is that this is not a battery because we didn't physically touch him, and but the court said that it's particulate matter. So in that particular matter, touched his face. This is also it was harmful or offensive to a reasonable person, and therefore a battery was committed. Um, so and we can also talk about the new doctrine of extended personality. So let me add that right here. So now we get to color this in as I'm sorry if I'm going really fast through this, but we're just gonna I'm just gonna kind of go through really quickly. This is kind of like just a crash course into what I'm doing. So contact does not need to be with the person. So ask yourself, right, to what extent could you consider it a part of a person. And this is a part of the extended personality doctrine, right? The extended personality doctrine is saying that an object, depending on how closely it is to your person, if someone grabs it, touches it, that can be deemed an assault. And we can look at extended personality almost in the sense of a spectrum, right? So we'll look at, for example, if someone touches your wheel, if you're in a wheelchair, someone touches it, and you're expressing that you don't want to be touched, and they still do it, right? That is a battery to your extended person. Therefore, it's a battery to you. Yanking the scarf off of someone's neck who's wearing it, right? That's that's touching you. If someone pulls that thing off, that affects you. Borderline, right? Whacking someone's cane and leading up next to them. Yeah. Really interesting example is if someone is in a car and someone is hitting the car while someone's in it. Is that a battery? Well, it can be argued either way. And the absolute example of not being a battery, right, is someone taking a picture of you and then like ripping it up. You can't be like, oh my God, they battered me. It's just a picture, bro. It has no contact with your physical person. So I kind of look at it as just like how closely associated is your body in relationship to that object. Maybe one can argue if they have a wand and someone slaps the wand out of their hand, they're a wizard, like that was a battery that was committed against them, right? The contact is harmful or offensive, right? So offensiveness is an objective standard, offends a reasonable sense of dignity, right? This was kind of discussed in Cole v. Hibbard, and you have to look at the totality of circumstances. So who is touching, the relationship between the plaintiff and defendant, and the setting for which it occurs. All this has to be kind of thought of when you're making that particular maneuver, or we're making that particular claim, excuse me. 1 second, guys. Let me just try and remind myself Cole v. Hibbard real quick. Here. Got it. All right. So in Cole v. Hibbard, the defendant, Cole, she tried to argue that, the interact, like, so the woman was walking with her stroller and she was talking to her two friends, it was a guy and a girl. I think they were a couple, they were drunk. And one of the friends, Hibbard, I believe, kicked her in her back and she fell to the ground. And I believe she was trying to argue that it wasn't a battery. What she's trying to argue for it, other than that being is irrelevant. Because the court said that even though you're saying that it's not a battery, this is obviously a battery. So because it's an objective standard, right? So Hibbard, let's go back to the top. Hibbard, which was the defendant, acted, which was the kicking. That kick intended to cause contact with Cole, right? And getting kicked in the back, right, is harmful and offensive. And you're slamming to the ground, right, with your while you're pulling the stroller. And the contact that Hibbard made towards Cole caused Cole, I think she had a back injury after, to suffer a harmful or offensive contact. Boom. There are certain defenses against a battery. The first one being consent, right? So it's worth noting some districts make plaintiffs prove the absence of consent, and then others make D prove the absence of consent. Oh, I think hold on 1 second, guys. While I'm doing this, I gotta edit still. All right. See if I got that right. Got it. Got you. Yeah, got it right here. So not it's D. So other districts allows D to prove its presence. So you guys got to show that, yeah, like you did have some kind of consent, or you did have consent, not some kind of consent. Consent can be expressed or implied. So expressed, the person tells you. I believe the way that you improve the implied consent, got to look at the totality of the circumstances, right? The relationship between the individuals, the environment, and there's an objective standard, right? Did the defendant believe they had consented? Would a reasonable person believe that there was consent in that relationship or in that interaction? Excuse me. And it's not valid, right? If there was coercion. So, for example, if I tell you like, "Hey, let me touch you, or I will fucking kill you," I'll put a gun in your mouth and you do what I say. You cannot say, "Oh well, they consented to do X, Y, or Z." There was a threat of violence. And another note, right? You can't consent to everything, right? So you can't say, "Hey, man, like he consented to me killing him." No. Let's look right now at the scope of consent, right? The scope of consent consists of a couple questions. Where did this occur, right? By whom and for what reasons? So really a really contentious case, really controversial case is Kaufman. So in this case, there was a young boy. He was on a football team and he was a middle schooler. And there's this coach, really overly enthusiastic coach, wanted to teach the young boy Kaufman, how to play, how to like do some good, how to handle some good defense. Grabbed the kid, picked him up, threw him in the air, caused the kid to injure his arm, right? So, which is just, it's insane. Now, a person could say, right? Well, what do you expect, right? Like you're going out there to play football. It's implied that you're going to get hit. You can't sue, right, for battery, for the tort of battery, if there's an assumption that if you know you're going to get hit, right? But the thing about Kaufman, right, is that your parents are expressing, or parents are consenting, and the parents are allowing their kid, like the parents are consenting to their kids getting hit, right, by other students. No parent is thinking to themselves, "I want my 10 or 11 or 12-year-old, 13-year-old son to get slammed by a 40, 50-year-old man." Right? So you have to look at the question, where was this though? Right? This was on the football field. All right. But by whom? It was the coach. That is not an implied level of consent, nor was it expressed consent to do that to that kid. It's not right. So factors to consider when thinking about the scope of consent: was there parental consent? Was this mandatory? So this Kaufman fails on two of these. And was there no reasonable alternative? There was a reasonable alternative. You would have one of the other students perform the maneuver on each other and see what happens there. That is reasonable. That is rational. Let's look at, for example, let's look at self-defense right now. So self-defense is an objective standard. So only if D actually and reasonably perceives an imminent risk. So this is a really powerful point here. The risk can't be, "Hey, look, I'm gonna get my Glock from upstairs, and when I come back down, like, yo, it's on." Right? You can't then be like, "Oh shoot, I'm gonna go kill the guy now." Like, no, it has to be right there. It just has to be an action, right? And it must be proportionate, right? So force that is deadly or can cause serious harm is only justified with the same proportionate force. So if someone's punching you and fighting you, you cannot come in, right, and just stab the individual. If it is not objectively, if it's not objective that the harm that they're going to provide to you is death, right? It's hard to argue self-defense if you in that type of fashion. Another thing, right? You can't say it's self-defense when you're attacking someone if they're just trying to take your property. So an example of this is Catco. So in Catco, this guy has a vacation home, and in his vacation home, it's basically abandoned. People come into that vacation home and rob, take from it, whatever. And so Catco is like, man, you know what? Like, this is like a perverted Home Alone. So Catco says, you know what? I'm going to set this thing up now. He puts a Glock. I know he puts a weapon in the room, like a gun. Like I think it's a shotgun. And what happens is if someone opens the door, the shotgun is triggered, and then it shoots them. So he sets up a trap for a potential thief. So the thief comes in, opens the door, and gets his freaking knee blown off, I think. And then so now the guy who owns the home is being sued by the trespasser. And so the holding of that case, right? A person in protecting his property may not use force calculated to cause death or serious bodily injury, except where there is also a threat to someone's personal safety that justifies self-defense. So the law, right, from what my professor was saying, the law views human life as being more valuable than property. And another thing is, right, you can't shoot someone to protect another person. So if someone's coming to kill Jerry and you want to protect Jerry, while they're reaching out for Jerry, you can't shoot that guy that's coming to shoot Jerry. You know, that's what it is. All right. Okay. Let me just make sure I can see how long this is going to go for. It's going to be a little while. All right. Let me just go through assault, and then if I feel like moving forward, I'll move forward. But if I feel too tired, I'm just going to kind of stop. All right. So, for example, what the elements of assault is that the defendant acts. So similar, right? The first similar to battery. So the defendant acts. They intend to cause apprehension of an imminent and harmful contact. Excuse me. So assault is different from battery in that battery involves a contact. Assault only requires that the person feels a sense of apprehension of an imminent and harmful contact. So let's go into towards the intent. So D must intend the apprehension or have substantial certainty that apprehension would occur, right? We already went through a substantial certainty meant before. So I think what it's just saying, like, you would have the sense or the reason to think that, you know, any reasonable person would feel a sense of apprehension of a harmful or imminent contact due to this behavior. So I use two cases. That kind of like we kind of go into the assault point. They kind of flip. All right, and when I say flip, one is in support of assault and the other is not in support of assault, right? So the first case is Vetter v. Morgan. So in Vetter v. Morgan, it was a woman who was driving her car 3 a.m. So it was early in the morning, dark outside, and these couple of guys are driving their car next to her. They're making loud noises. They're threatening to harm her, all that jazz. And she gets really nervous. They act like they're gonna throw her off the road. Some of them are spitting on the vehicle. One of them is encouraging the level of violence that's being directed towards her, and what they're gonna say is, hey, like, we did not intend. There are and it ended up with her going off road and hurting herself. Now, Vetter is saying, you know, this wouldn't happen if not for, you know, them threatening me, and she wanted to sue for assault, right? You know, the guys are saying, look, we didn't mean to do that. We didn't even take whether or not she thought it would be harmful or offensive as a matter of a consideration, which is a very evil thing to say, right? And just kind of like just very strange. But the court found, right, that threatening words may form the basis of an assault claim where they are accompanied by conduct or circumstances leading to a reasonable apprehension of an imminent harmful or offensive contact. So despite them, it's similar to Paul v. Holbrook. So despite them saying they didn't intend on doing this, if you look at the totality of the circumstances, any reasonable person would feel like they were in imminent threat of a harmful or offensive contact. And, this is what occurred. Now, something is very different with, sorry, my dog. All right. Something's very similar with Brook v. Silverthorne, excuse me. Champion, please. It's my dog, guys. All right, Brook v. Silverthorne, right? Which is about this woman who's working as basically, back in the days, used to have like the phone companies, people would like transfer like phones over and all that stuff. Like, hey, give me Bob, no problem. Bob, you're transferring Bob. All right. So she wasn't really good at her job. And Silverthorne said, if I was there, I'd break your freaking neck. If I was there, right? Brook felt very afraid about this. Like, she was terrified. She was like, oh my God, like, I feel bad. And she was missing work. She was feeling horrible about this, all that stuff, and try to sue Silverthorne for assault. Now, the reason why this, even though it was an awful thing what Silverthorne did, the reason why it didn't fulfill the assault claim was that it was not it was not the apprehension was not based on an imminent harmful or offensive contact, right? So what that means is that she can't sue for assault. If someone says, one day in the future, when you're not expecting it, I'm going to come get you, that is not an imminent or harmful contact. It's not, because it's not imminent. So it can't be an assault. So Brook's claim for assault was rejected by the court. All right. So apprehension. So must be reasonable, right? Depends on the context, such as tone, accompanying gestures, physical circumstances, and relationship between the individuals. Yeah. So it doesn't matter what, like similar to Vetter v. Morgan, it doesn't matter whether or not the individual believes that they're going to actually cause the harm. It's not the same, but like, so for instance, in Allen v. Hannaford, the tenant was going to leave the property, and they were taking some objects that was in the apartment with them, under the assumption in their mind that they owned the property that they were taking from them from this rented apartment. Hannaford said, "Nah, this isn't cool," and walked over, right, to Allen with a gun. Right? Hannaford said, "Hey, like, I wasn't gonna do nothing." The gun was empty, but a reasonable person who was being approached by a gun would believe that there was some bullets in it and felt like they were being assaulted. And a reasonable person would believe that was an assault, even though Hannaford did not intend on shooting Allen. Now, if Allen knew there was no bullets in the gun, and Hannaford had no bullets in the gun, then that is not an assault, because there is not a threat of imminent harmful or offensive contact. Now, imminence. Let's go to that point. So imminence, right? Threat for contact on a future date or on a condition is not an assault, right? A general, I'll get you, or I'll be back in a few minutes with a weapon, doesn't work. So example, as we talked about in Brooker's Silverthorne stated, if I were there, I would break your goddamn neck. That did not constitute an assault. Interesting point here. So apprehension does not necessarily have to equal fear. So mere awareness of imminent contact is sufficient, even if you are not afraid. Now, what does that mean, right? Like, yeah, like let's say someone has like the nerves of Batman and feels no fear. Just the fact that they think someone is going to come get them still leads to that to that element being filled. However, right, a lack of fear can affect compensatory damages. So you might have a lot less damages if you're not having that fear. So let's talk about damages. Provide these things pass the proximate cause analysis, you get pain and suffering, lost wages if you did not go to work for a week. Again, similar defenses are consent and self-defense. So I got some more energy, guys. I want to go through all of this, man. I don't even got some more stuff a little later. So I'm probably gonna go through IED and then I'm probably gonna head out. All right. So let's talk about the intentional infliction of emotional damage, which is extremely hard to win. And some states, something interesting note, some states do not require evidence of severe emotional distress. So why use it? People use it when there is no other tort claim available. So if you have something else instead, use it. If you can use assault, use assault. If you can use battery, use battery. And then cite pain and suffering as part of the damages. So people use it, right, because the statute of limitations have passed on assault or battery. I don't know how long the statute of limitations lasts for assault and battery. I think it's like it's in between 1 to 3 years. Don't quote me on it, but I think it's like 1 to 3 years. And it could be state dependent. It probably is state dependent. Anyways, so statute of limitations. So for example, we're going to use Dickens. So in the Dickens case, the plaintiff slept with the defendant's teenage daughter, underage daughter, gave her some liquor, all that stuff. And the defendant heard about this, what the plaintiff did, found the plaintiff, brought him to a barn, I believe, and beat him, cut his hair, and threatened to cut off his genitalia if he were to ever come back into town. Now, at this point, Dickens sued and for IIED, and he used the assault and battery as evidence for the IIED, and the court found in his favor, found in the plaintiff's favor. And the court held a threat of future harm may give rise to a claim for intentional infliction of emotional distress, where he argued, right, because assault and battery, statute of limitations passed. However, the assault and battery Dickens experienced were used to heighten the credibility of the future threat and indicate levels of distress. So the elements of IIED, right? The conduct must be directed at that person, right? The second thing, the conduct is outrageous. So a reasonable person within society would be like, oh my God, this is disgusting. What makes this element, in my opinion, pretty controversial? It's still the element, you still got to use it. It's just kind of uncertain. As you go along within law school, I think you're going to find that like rationality, I think you're just going to find like the rules are not stable and they can be argued either way. So outrageousness is a social fact / objective standard. Now that is confusing. How can it only be a social fact and objective standard? But just stay with me here. The average person in that community needs to scream outrageous. So it depends on the community, right? So for example, in Littlefield, the community was really disgusted by the actions of a landlord who was extremely racist to his tenant, who was a white woman, but she had a biracial child and was with a Black man. And because of that, he discriminated against her. So the community said, this is outrageous. And he threatened to, do all types of stuff to her. And she was very stressed out at her job and all that stuff. So the court found in favor of her. Now, this is because it was probably a pretty good community, right? And I put in the note, might be decided differently if the community was filled with racists, people who were insensitive to racism, right? Another example, right, is Jones v. Clinton, right? Holding, and in this case, Jones sued President Bill Clinton for sexually assaulting her. And the court found that, it wasn't really IIED because it happened over the course of one day, in a couple of minutes. So it didn't rise to the extreme and outrageous conduct that community felt. So they were really like passive with it. So holding for Jones v. Clinton. Determining whether extreme and outrageous conduct rises to an actionable tort for intentional infliction of emotional distress in Arkansas involves an analysis of the conduct at issue, the period of time over which the conduct took place, the relationship between the defendant, and defendant's knowledge that plaintiff susceptible to emotional distress by some physical or mental peculiarity, right? And so, right, the community said the sexual harassment was not deemed to be outrageous by the community. So the element 2 of IIED was not met, so the case was thrown out. Do with that what you will. The law does not say what counts as community, and there is some space for the law to step in when the community, quote unquote, gets it wrong. Distress is unendurable and unignorable. Courts can very callously argue. Excuse me. Oh gosh, I'm so tired. Sorry guys. It's like 11:32 p.m. The courts can very callously argue that you still made it out with your life. So, the stress you experienced wasn't unignorable. Some courts go crazy. And some courts have allowed this to apply reputational harm. And some jurisdictions hold that punitive damages are not available since outrageousness is an essential element to IIED. But some punitive damages of IIED was especially outrageous. Don't worry about that. Let's move forward. And then damages can only be met for your emotional distress. The type of damages that you can receive are compensatory and punitive. So compensatory damages that are intended to compensate for actual injury or economic loss, right? So if you're missing a couple of days from work, or if because you were under such emotional distress, the court will award you that money that you missed out at that point. I said this before, but it's good to restate this. Punitive damages, right? Damages awards plaintiff over and above just compensation in order to punish the defendant and serve as a deterrent. So this is more of a utilitarian punishment. Utilitarian refers to punishment that provides the greatest utility or the greatest influence to a large number of people. So, for instance, with the Littlefield case, the property owner was like, "Whoa! I'm paying too much in damages. I'm paying way too much in damages, right? I did this doesn't match up with the amount of money that was spent here or was taken here." But the court said that when your behavior is so extremely outrageous, we want to make sure that no one behaves a similar way. So we're going to look at how much money you're earning and do what we can to really hurt your pockets so that you and no one else likes you feels like you can do this to another person within our society. All right, guys. So the next time we meet, so I don't know when that will be, probably next weekend. I'll probably be talking about negligence, and I'll probably be talking about another topic as well. I'll try not to make it this late next time. But stay up, stay smart, keep learning the law. Guys, definitely have someone that you guys can reach out to. I'm not someone that is actively on YouTube responding to people. Gonna be 100% honest here, but I do it whenever I can, and that's all I can do is my best. But it's always a pleasure interacting with you guys and helping any way that I can. I'm probably gonna read and then I'm gonna go to bed. So good luck, guys. Law school is a lot of fun. I think you're all gonna really, really enjoy it. I think law school can be a little bit isolating because of the race issue. But other than that, you're gonna love it. It's a really good thing. Hopefully my YouTube channel can give you a good crash course in understanding what's going on here. Hopefully it can. All right, guys. Peace.